The State Bar has two major categories of disciplinary proceedings. There are informal proceedings before the Grievance Committee and formal proceedings before the Disciplinary Hearing Commission. If you've received the dreaded certified letter from the State Bar about notice of a grievance, you may be wondering what it means. What it doesn't mean is that the State Bar believes all the allegations that they've put in the substance of grievance that accompanies the letter of notice. It also does not mean that the State Bar has already concluded or made any determinations about the potential rule violations set forth in that substance. All it really means is that someone's filed a grievance or a complaint against you with the State Bar, and that an attorney that's been assigned to review the grievance has determined that the allegations in it, if proven, would state a rule violation or multiple rule violations. If you handle civil cases, it's similar to a Rule 12b-6 standard where if you take the allegations in a complaint as true, it states a claim or an asserted violation. There are several important things to consider in responding to a grievance. First, you must directly address the allegations set forth in the substance. Second, it's really important to limit additional information to only what is essential. Cut down on extraneous or irrelevant information in producing documents that weren't requested. You also need to use an appropriate and respectful tone in the response, and you got to take the grievance seriously even if you don't think it has any merit. The other major type of disciplinary proceeding before the State Bar are formal hearings before the Disciplinary Hearing Commission or the DHC. Hearings before the DHC have a couple of important components. The DHC is an independent tribunal who hears all contested disciplinary proceedings before the State Bar. Generally speaking, the rules of evidence and civil procedure apply in those proceedings with a few exceptions. Formal hearings before the DHC generally follow and are similar to a civil trial without a jury, including conducting pretrial discovery, putting on evidence and witnesses, making arguments and objections. As a result, it's often difficult for even a lawyer to represent themselves in a formal disciplinary proceeding. As an attorney, you may be trying to decide whether or not you need independent representation in a State Bar matter. I'm Doug Brocker, and our firm has substantial experience in representing attorneys before the State Bar in defending and responding to grievances, and also in formal proceedings before the DHC. One of the advantages that gives us is the ability to properly evaluate formal disciplinary cases and advise clients on their best options, whether it's taking the matter to a hearing or reaching a consent order with the State Bar to resolve the matter. I encourage you to consult with an attorney with experience in handling those matters and to do so at the earliest possible stage. There are a couple of reasons to do so. First, the most cost-effective way to protect your investment is to get representation at the earliest stages, which is generally the least expensive. Second, it's generally the best opportunity we have to help you achieve a favorable or acceptable outcome. There's additional information about more detailed procedures concerning the grievance process and the DHC hearings on our website under Disciplinary Process tab under State Bar. If you prefer to set up an individual consultation with a lawyer in our firm, you can either submit an inquiry through our website contact page, or you can call our main number and ask to speak with our firm administrator. We generally can conduct initial consultations either by phone or in person, depending on your preference.